This presentation deals with primary legislation and is the basic building block to any legal argument. The information presented here will deal with the UK and in most cases will also deal with other parts of the British realm. Some people have a difference of opinion as to what primary legislation is. So for the viewer, I will clarify that in my case, I mean primary legislation to mean the fundamental creation of government and the current law system, whereas other people take primary legislation meaning legislation before it was modified. For example, if the Highway Act had a modification, they would insist that primary legislation was the act before the modification, and now that it's been modified, they would call that secondary legislation. For clarity, I'm referring to primary legislation as the basic fundamental documents which created the current legal system. Before we begin, I must inform the viewer that any action that they take as a result of this information is entirely the responsibility of them and not of the presenter or of the web hoster that holds this information. Every attempt has been made to verify that the information presented here is correct and is in fact based on current legislation. However, many times certain legislation referred to may change or may be amended, and it may not be up to date. It is therefore the responsibility of the viewer to ensure that the information presented is accurate and is up to date, and ultimately they are responsible for how they use or misuse this information. The creation of government, as we currently know it, started out in 1688, and it could be traced back to other years prior. However, in 1688, they basically wiped out the old legal system and created the new legal system. If we note here, there's a seal at the top of the document denoting that it comes from the Crown. Now, it says for preserving doubts and scruples which may arise concerning the meeting and sitting of and proceedings of the present Parliament. So it's telling you right there, if you read through it, that this is actually the current system we use. If we want to check into it further, you can also refer to the Statute Law Revision Act of 1948, and you can see what current rules or current statutes are currently on the books and still valid to this day. If we look at the Bill of Rights, and this is only an excerpt of the Bill of Rights, it says the subject's rights. It says thereupon said Lord Spiritual, Temporal, and Commons, pursuant to the respective letters and elections, being now assembled, full and free representative of this nation, taking into the most serious consideration the best means for attaining the ends aforesaid, do in the place, as their ancestors in like case have usually done, vindicating and asserting ancient rights and liberties declare, and it gives a declaration. Well, it's telling you right here in the Bill of Rights, 1688, that they're respecting your ancient rights and your ancient way of doing things, and everything from this point forward should be done the same way. And it says dispensing a power, that the pretend powers of suspending laws and execution of laws by regal authority without consent of Parliament is illegal. That's telling you right there that everything that happens with Parliament is supposed to be done and sanctioned by them. And in fact, if we do a little research, we find out that in, I think it was 1867 or 1887, somewhere in that neighborhood, the laws did not receive royal assent. And anyway, it says ecclesiastical courts are illegal, and then it says levying of money for the use of the crown by pretense of prerogative without grant of Parliament for a longer time or other manner of the same is and shall be granted is illegal. And with that, I would draw your attention to court cases that have R versus whoever, which means Regina, which represents the Queen, without the consent of Parliament would be illegal. And in fact, Regina and or the Parliament / Crown, in fact, is not involved in any court case and will never appear in a courtroom. Therefore, how can they be your accuser? You have a right to address your accuser, which makes all court cases done in this fashion null and void. It also says that the freedom of speech and debates from proceedings in Parliament ought not to be impeached or questioned by any court of the peace out of Parliament. Now, if you notice, the word Parliament is spelled different. It's P-A-R-L-Y-M-A-M-E-N-T, which is Parliament, not Parliament. The two houses of Parliament is the current system that we deal with, and Parliament represents the Crown. The Coronation Oath Act 1688 basically sets out the framework that states that the future kings and queens have to take an oath to the Crown, and it basically protects the statutes, laws, and customs of the realm, of all the people, inhabitants thereof. This further implies that the agreement between the people and the Crown is by, in some way, a contract. And this goes back to our initial Act of Will and Mar and the creation of the current government. If we look at the Coronation Oath Act 1688 further, we see here oath administered to all future kings and queens. And it says a said oath shall be in like manner administered to every king and queen who shall succeed the imperial crown of this realm and the respective coronations by one of the archbishops or bishops of the realm of England. Now, I would argue the point and say, well, why is the archbishop or bishop having anything to do with legal matters in Canada, which gets into a different issue dealing with birth certificates, and we'll get into that at a future presentation. But this affirms now that even the fact that this is in 1688, all future kings and queens must swear an oath. And that oath is to uphold the rights and liberties of the people, as we're going to see in a future slide. The Act of Settlement made it very clear. It says it recognizes the birthright of the people thereof, and the kings and queens who shall ascend the throne of this realm ought to administer the government of the same according to said laws and their offices, and ministers ought to serve them respectively according to the same. It goes on further to state that the laws and statutes of the realm for securing the established religion and the rights and liberties of the people thereof, and all other laws and statutes of the same now in force, may be ratified and confirmed, and the same are by his majesty, by and with the advice and consent of the Lord spiritual, temporal, and commons, and by the authority of the same, ratified and confirmed accordingly. What that's telling you is these current, as I call them, primary legislation may be modified, but they can never be abolished. Now, if we go back to this Act of Settlement, it's very clear now that any law that happened prior to the 1700s and any law thereafter must receive royal assent. We can get into some more of that in a future video. However, any law that's contrary to this is, to the extent of the inconsistency, null and void. If we look at the Treason Act of 1695, it says right here, the act regulating the trials in cases of treason and misprision of treason. Now, basically what this is telling you is that if a person operates against the rules or statutes of the Crown, they could be tried for treason. So if any government tries to assert their whims as far as council tax or a court proceeding which does not specifically follow the rules that were already set forth, those people can be held in contempt of court and or tried for treason. The Great Seal Act 1688 further affirms that where the Most Excellent Majesty or King William and Queen Mary have thought fit that an office of the Lord Chancellor or Lord Keeper of the Great Seal of England should be executed by commissioning appointed for the same under the Great Seal of England, and where several authorities, jurisdictions, and powers are by several acts of Parliament and otherwise vested, sealed, and placed in the Lord Chancellor of England or Lord Keeper of England, Great Seal of England, for the time now, and preserving all doubts and questions that may arise whether all or any of these authorities, jurisdictions, and powers be executed by such commissioners. So in English, what this is telling us, since we want to convert it to something everybody can understand, basically all acts and statutes are to be receive the Great Seal of England, and it should be done by the Lord Chancellor or the Lord Keeper, and not necessarily by the Crown itself. Now, this raises the question then, any act that has not received royal assent or had the administration of the Great Seal is to that extent null and void. And if it's null and void, it cannot be used as legislation to reach a legal determination. Now, it says, commissioners of the Great Seal may execute the powers entitled by the enrollment of the Chancellor their place. Such commissioners, for the time being, may use and exercise at all times, according to their commissioners, as a right belonging to the Lords Commissioner of the Great Seal of England. For the time being, all and every same and alike, officers, authority, jurisdiction, and execution of laws, and all other custom privileges. So it says at all times. It doesn't say sometimes. It doesn't say only on Wednesdays. All times. Therefore, any act or statute which does not receive the royal assent and or the Great Seal, which has to be approved by Parliament, meaning the Crown, is to that extent null and void. So, Modern Slavery Act also falls into play here, that if a person is trying to make you into a slave or make you pay some fee or something which is not lawfully executed under the Great Seal or as an invalid statute, or in fact some sort of a bylaw which is not legally binding, then they could be convicted under the Modern Slavery Act. These principal arguments I've brought forward here can be used in the UK and may be argued in other British realms as well. However, there may be overlapping or overpowering rules or laws or regulations which make these arguments null and void. As such, it is up to the viewer to verify that the information presented here isn't actually applicable in their country. Canada, for example, has quite a different setup, even though we operate under the British realm anyway. And there's a totally separate video dealing with that specific matter. And as such, it will be dealt with accordingly and goes into great depth to the construction of Canada, the country, and the laws contained therein. Specifically, I will address many issues dealing with the province of Ontario within that demonstration or within that presentation. However, the laws that I present there also in some cases overlap to the federal jurisdiction as well. But this presentation here applies to England and the other areas around which operate still under the British realm. If we look at this slide, we see a case here, and this is a case that's gone through the UK courts, and it's on application of Miller and another respondent versus the Secretary of State, and it's dealing with the exiting of the European Union. Some people may remember that they had a thing called Brexit, which is where Britain exits the European Union. You can look this case up and find it on the internet, and I can also provide a link to it at the bottom of this presentation. This case is very important, and I will go through this case specifically at a later date because there's a number of arguments here which can be used in any court action or a lot of court actions depending on the context. But most importantly, if we look at one specific point in that argument or in that presentment, we find the following. At point 46, it says, "It is true that ministers can make laws by issuing regulations and the alike, often known as secondary or delegated legislation." Now, remember I talked about primary legislation in this presentment, and this case affirms that secondary legislation is anything that's not passed through the proper channels. And it carries on to say, Basically, save in limited areas where the prerogative power survives domestically, as exemplified by the cases mentioned in paragraphs 52 and 53 below. So it's telling you there the prerogative power, which is our primary legislation, survives. They can do so only if authorized by statute. So if the regulations are not authorized, they will be invalid, even if they've been approved by resolution of both houses under the provisions of the relevant enabling act. And then it says, for recent examples, see R versus Public Law Project versus Lord Chancellor, 2016. So this is telling you that even if they pass some kind of a law or an act or a statute, and it's contrary to what is the original legislation, the primary legislation, as they've even referred to it in this case, it makes that act invalid to the extent of the inconsistency. In other words, if we look up the word confer in a legal dictionary, we find out it must get its authority from. Therefore, all statutes and acts that are passed today must confer or get their authority from the primary legislation. And this is now cemented in law based on this precedent case. It may be in other cases as well. But you can always refer to this case as an example to support your claim. This presentation has been brought to you by Denied Truth, and we can be reached at deniedtruth@yahoo.com, or we can be contacted on the Telegram group in the address listed directly below the email. I hope you found this information useful, and I look forward to bringing you further information as time permits. If, however, you have a specific issue you would like addressed, please send your request to deniedtruth@yahoo.com, and I will see what I can do about addressing a specific issue. I thank you for taking the time to listen to this presentation, and you should also look for a YouTube channel under Stan McDonald. On the YouTube channel, you will find many videos listed and discussing a number of topics, everything from ULEZ to council tax, to paying taxes, to your rights in court, and how to present court files and court arguments, how to write an affidavit, a number of other topics. I hope you will take the time to find the channel and subscribe and like the content, as it helps me expand further, which in turn helps you. Thank you, and goodbye.